Adams, and we're going to talk about a holiday pay case today, and one specifically that relates to part-time workers. Blair, why are we looking at this area?
Well, it's an important case in the Court of Appeal that has overturned some of the established thinking about how to calculate holiday pay for certain types of part-time worker. And I think as a result, some employers will need to reevaluate how they treat part of their workforce.
And which case are we looking at?
It's called Brazel against Harpur Trust. It involved a music teacher, Mrs. Brazel, who worked at a school. She was a peripatetic music teacher, so she taught lessons as and when required. She had irregular working hours. And although she only taught during term time, one of the key things about this case is that she was engaged on a contract that ran throughout the year.
So she wasn't a 0 hours contract, is that right?
She was, that's right, yeah. She wasn't described in that way in the contract. The school didn't treat her in that way, but in reality, she was on a 0 hours arrangement where the school called off her work, if you like, when lessons were required. But the key difference was, as I said, she was employed on a contract that ran throughout the year.
Yeah, and we've just put up here on the slide which workers that this case affects, and that's those workers who are employed throughout the whole year but only work part of the year, and those workers that work irregular hours and so have irregular weekly pay. So this case was about the education sector, but would it be relevant to other sectors as well? So 0 hours workers in a different sector?
I think it could be. Again, provided they are the type of worker that has an all year round engagement and works irregular hours and therefore has irregular pay. Other types of workers arguably won't be affected.
Okay. So what were the main issues in the case?
Well, the main issue was how to calculate her holiday pay. The school had been using the 12.07% formula that's widely used with 0 hours workers. Mrs. Brazel challenged this. She said that using that percentage involves an element of prorating, but as a full year worker, she had the full 5.6 weeks holiday entitlement under the working time rates. And she said there was no basis for prorating her holiday pay.
And what was the outcome of the case?
Well, Mrs. Brazel won,
right.
Which is why we're now analysing this case in great detail. And the difference is significant if you compare the holiday pay she was getting using the 12.0% against what she was claiming. There's a big difference.
And we're just putting up here on the slide actually two different scenarios. The first is where it is using the old calculation where the percentage of 12.07 is applied. And so if we take, for example, a school invigilator who's employed on a year-by-year permanent contract, but just for the exam period is the period that they actually work. So here we've got up on the slide, they're working for 3 weeks of the year. The first week they work 10 hours and are paid a rate of £10 per hour, so giving a total of £100. And then we've got the hours that they work for weeks 2 and 3. So a total of 19 hours over the 3-week period. Applying the percentage of 12.07, that gives a rate of 2.3 hours, which have accrued over that period. And applying their normal hourly rate of £10, that gives a holiday pay calculation of £23. Whereas in the second scenario here, we've got the calculation that was applied in the case of Harpur Trust. So the same working pattern as in scenario 1. If we look at what their average weekly pay is over the prior 12 weeks, that gives a figure of £63.33, and then you multiply that by 5.6 weeks for their holiday entitlement for the full year, and that gives a holiday pay calculation of £354.67. So really, the way in which it's been calculated in the Harpur Trust case does result in a significant difference in the level of the holiday pay. Now, the approach of paying holiday pay using this calculation of 12.07% has been applied quite widely. I mean, it was even included in the ACAS guidance. Is that now wrong?
Well, you're right. It's very widely used, and I think it probably is now wrong for a certain type of worker. So that's the worker who has the year-round contract, but who has irregular working hours, doesn't work a full-time year, and therefore has irregular pay.
And will it apply to all zero-hour workers?
No, I think many zero-hours workers are on contracts where the contractual relationship only exists during their assignment. So whether that's 1 hour or 3 days at a time, there's no contract that's ongoing between assignments. So they're in a different category from Mrs. Brazel. I don't think they'll be infected, but I think there are many types of zero-hour workers who may seek to argue that they are on a Mrs. Brazel type contract because they're engaged all year round.
So it's really important to check the wording of your contracts.
Yeah.
So thinking about part-time workers more generally, will it have general applicability across part-time workers?
It will apply if you're a part-time worker who has an irregular arrangement. But the classic part-time worker who works, say, the same 3 days every week and the same hours on those days won't be affected by this.
And so why are those two different categories treated differently?
Well, I think it ultimately stems from the working week, because under the working time regs, holiday is calculated according to the working week. If you have a regular working week, your holiday is prorated. So if you work 3 days out of 5, you will get 3/5 of the 5.6 week holiday entitlement. But if you have an irregular working week, there's no mechanism in the working time regs for calculating your holiday pay. So you have to turn to the Employment Rights Act provisions and look at some of the sections in there that have been analysed in lots of holiday pay cases. And what they say is if you have irregular working hours and therefore regular pay, your holiday pay should be calculated on the basis of the 12 preceding weeks.
Isn't it odd to make a distinction like that?
It does feel quite odd, and a lot of the commentary about this case has highlighted it's quite an odd result. In fact, in the decision, the Court of Appeal admitted produced an odd result on the facts, but they didn't see there's anything necessarily unjust about that. The problem is that the Harpur Trust, the employer, was trying to do something that's not expressly permitted by the working time regs.
Yeah. So the key points for employers from this case, we've just put these up here on the slide, is firstly to check whether you have any workers who are part-time and do not work regular hours. Secondly, to look at what contracts they're on. So are they on a 0 hours contract or a part-time contract which is permanent, or is it an assignment by assignment basis? And then next, to just look at how you're calculating holiday pay currently and whether that needs to be changed in light of this case. Should you, if you are using the 12.07% formula or some other pro rata approach, should you continue using that, or do you need to adopt the approach set out in this case? Some employers are going to want to be proactive and introduce changes immediately. Other employers may want to see if they're challenged by staff about the calculation of their holiday pay, and then look at, we'll revisit it at that point. Now, if a worker does challenge their holiday and how that's been calculated, could they bring an employment tribunal claim in that situation?
They could. The good news for employers, though, is that they can only look back for 2 years. So the liability is essentially capped at the last 2 years of underpaid holiday pay.
So it's limited to some degree in that it can only go back, or claims can only go back for 2 years, but it still could be significant sums, as we've seen from the scenario.
Absolutely.
Well, that's all for today. If you have any questions on this topic, we've put our contact details up on the slide here, and we'll be delighted to answer them. And we look forward to seeing you for another Employment Law seminar in due course. Thank you.